right, Islam Wars. How do we look today? I can't see what's going on, Trey. You gotta check that. Plus, you gotta check the live feed. So just refresh that page and see if we get anything. I can't see anything.
What you mean?
Can you see the live? Is that it? Okay, good. Now I don't need to see it. If you go too big, you might see.
So you chilling?
Go. Okay, let's look this way. How do I look?
Yeah, you good right there too.
All right, Islam Wars. Please let me know if you can hear me. I know we just started and nobody is on yet because it takes like a multitude of time for people to get on, and this is the first time I've been on live without being able to kind of do two things at one time. So Islam, there we go. Who the heck is that? Okay. Islam Wars. I don't know. I don't like being on this side. Islam. So anyway, today's class is on false arrest and imprisonment. So it's technically called arrest. I don't know if you can see, and false imprisonment. I know I'm late today. I'm still trying to tinker with this new platform, so please bear with me. And we need to do a sound check to make sure everybody can hear me. So if you can hear me, please let me know if you can hear me or if you don't have an issue hearing me. Can you hear me? Islam Moabite, Islam Razin. What you trying to do, Trey? Can they see it? It's facing the right way? Okay, I'm just making sure.
Go ahead.
Islam, okay, so this class is on arrest and false imprisonment.
They can hear you. Go ahead.
They can hear you?
Yes.
If anybody remembers what the 4 or 5 principles are in regards to this class on false imprisonment. So if you got your handy dandy book that everybody was told to download on the site, from the site, the YeSharon Moabite Star Academy. On the YeSharon Moabite Star Academy, we have the treatise on arrest and false imprisonment. It's a PDF. You can definitely download it. And there's assignments as well as homework and as well as a test at the end of the document, y'all. So I know I haven't been in class for a couple of weeks because I've been preparing and trying to make this class more interactive. My son is the videographer behind the scenes. Say hello, yes, Trayvon. He's like, I'm not saying hello. All right. So I guess the question is, does anybody remember where we left off in our last false imprisonment class? Does anybody remember where we left off in our false imprisonment class? So that's open to, I know Moors don't like to kind of participate. They're not used to participating. I'm looking at the screen because the questions are on this side and I'm not necessarily used to just being on the platform by myself. So please bear with me. I'm going to start with the first part, arrest, right? So we got, the first section is on false imprisonment. Does anybody know what false imprisonment means? I know I'm going backwards.
Somebody said, I believe it was page 6.
Page 6? What was on page 6? Page 6 has, that's still under false imprisonment, is page 6. So overstand, I'm just going to give like an outline on here, and then I'm just going to refer to the outline. So the first thing is false imprisonment. Now, if we go into the chapter and we go into the sections, what constitutes false? What does false mean? False consists of what false means is a unlawful restraint, right? It's an unlawful restraint. So you got unlawful, which is the false imprisonment, which is the restraint. So false imprisonment translates into unlawful restraint. And restraint means restraint is when someone is prohibiting you. So it means when someone is prohibiting you or denying you the freedom of liberty, right? Freedom of liberty. I'm just giving you basic liberty or right? That's what false imprisonment means. This happens to us Moors in a multitude of ways. It happens to us through a multitude of ways. I guess my better question is, what are one of the ways that you can be imprisoned unlawfully, restrained? One of the ways that we talked about in previous classes was, say you're walking down the street and you are approached. You are approached by a policy enforcer or a peace officer. It could be anybody who stops you to have a conversation with you, thereby limiting and stopping you from your liberty, right? They're obstructing your liberty. But what is the thing that you have to say, or the thing that you have to make clear, right? You have to make clear intentions, right? So if somebody's walking down the street and then they get stopped by an individual who wishes to interact with that person, and 9 times out of 10, when you get stopped by an individual who wants to interact with you, that individual is usually an officer or agent. They're an officer or they're an agent to under the Department of, let's say, of Justice. Or other people would like to identify it as law enforcement. So let's call these law enforcement officers or agents. So they come and interact with you, and if you are being, you like this word, Moors, everybody likes this word. You gotta
welcome back.
You gotta detain, huh?
You gotta welcome back.
You gotta welcome back of Islam. It's detained. So if you don't have the freedom to move, and if someone's trying to speak with you, that is literally called a detainment. Now you have to determine whether it is unlawful or lawful. How to determine whether a detainment is lawful or unlawful, right? Because false imprisonment is an unlawful restraint, and a detainment is a type of restraint, right, Morris? So we have to understand what an individual has the right to do under their authority and what they do not have the right to do under the same authority. So one thing that people don't really necessarily identify is due process. These words are synonymous. Due process, if there's no due process, if your due process is violated, meaning a policy enforcer, just like any old human being, has the ability and has the freedom to ask you a question. So just like how you have like solicitors, I'll call them solicitors out on the street. I'm getting hot, y'all, because I got all these lights on me. I'm hot, and when I get hot, I gotta put my hair up. So bear with me because I want to get to the meat and potatoes and things. I'm hot.
I'm already knowing.
So what am I saying? I'm about to get a fan in here. So what I'm saying is, in order for somebody to violate you, they have to stop. They have to do something against your will, and they don't have the lawful ability to do it because they didn't follow due process of law. It's pretty much what I'm saying. And because Moors or black people, or however you identify, we haven't been taught the law. We just go with the flow. Like somebody stops us who has a uniform, whatever that type of uniform is, we just automatically comply. And we didn't challenge it. Well, why are you asking me to have a conversation with you? What's this all about? 9 times out of 10, that's the first thing you should be inquiring about. If you are walking and minding your own business and a policy enforcer or law enforcement agent of the Department of Justice wants to come to you and ask you a question, well, the first thing you should be asking is, well, what is this about? Why do you want to ask me a question? Well, we know that a lot of times our people don't get confronted or approached in that manner. It's usually hostile. It's usually aggressive, and they make a presumption that you have to interact with them. When they are in their official capacity, it is their responsibility to be doing it lawfully. What does that mean? If they're doing it lawfully, they have to follow due process of law, and if they don't have any things to validate why they are interfacing with you, well, then that's voluntary. Whatever you do, however you continue to interact with them, that is considered voluntary with your consent. So Morris, what I'm trying to tell you is that when you have an interaction, when a policy enforcer, whether it's when you're traveling in your private mode of conveyance, whether you're walking, whether you're even in a store and they just come up to you, you have to validate, why is this individual interacting with me? The first thing, just like if anybody came to you and asked you a question, the first thing you would say is, what would be the first thing you say? When somebody comes and introduces themselves to you, the first thing they're going to tell you is their name.
Right.
Well, the name is normally the first thing that an individual tells you. What's the second? The second thing, especially if it's a law enforcement agent under the Department of Justice, his responsibility, his uniform is not proof of identity, nor does it validate authority on its own. Think about, everybody goes outside and interfaces with the world in a costume. And the way you legitimize whether or not it's a costume or if it's an official uniform from an official individual is not only how they address you, but what type of credentials do they have on their persons to validate that you have to interact with them. It is how the meeting of the minds come together. So when a policy enforcer under the Department of Justice comes up to you and asks you a question, the first thing you should be saying was, no disrespect. I see that you are a law enforcement agent. I just need some validation from you in terms of, what is your name? Can I see your badge? Can I validate who you are before we even move forward? And a lot of times they're not even going, they're going to just point to this, right? They're going to point to, well, I am, half of the time they ain't going to want to tell you who they are, but their little badge or their little, which is going to tell you what their name is. It's not going to have their full name. It's just going to have their last name. It's going to have their last name to identify them, and it usually will have a badge number, but if the badge number is not on their uniform, it's going to be where they have a copy of their badge. It's like everybody know, I mean, the crazy part about it is most people don't even see these things. They don't even get this far to ask them, well, can I see some valid identification so I know who you are? These are things we have to do. I know the temperatures are high. We might be angry. We might be agitated. We might even feel threatened because of the way and the manner in which they're approaching you. But always realize, Morris, you are a law-abiding citizen or a law-abiding individual or persons, and they are the individuals trying to interface with you. So now you have to determine whether this so-called detainment, because at this point when they start interfacing with you and they're in your face, right? When they're interfacing you and they're in your face, they're making a presumption of authority, and you're making a presumption that they have the right to do what it is that they're doing, and that is not the case, and you should never go on that pretext. You should always, just like how, when you watch movies, you'll see, you'll get a knock on the door from a detective. The detective will knock on the door, and the first thing he's going to do or she's going to do is, well, I am, and she or he is, and here's our badge, just to validate who they are, so you know that it's just not a person wearing a costume. And I use that example so you can understand until they validate who they are. Because when the one thing that I get majority of the time with Moors, when they contact me for consultation or to assist them with just having a bounce off of ideas, the first thing when I am interfacing with Moors, when they have a question is, well, I understand this was an emotional experience that you had, but my job is to get the facts. Not all the other extra details that you want to tell me, just the facts as it relates to what happened. Once I have the facts, then I can consult you absolutely. And then as Moors are telling me things, I'm looking for the breach of due process. What happened? What initiated the interaction? How the interaction was initiated is going to let you know if you have a case for false imprisonment. Now, once we kind of get through, and I hope you're taking notes, you should have your handy dandy notebooks, because what I'm going to ultimately show you is a grid. It's going to be a grid because you're going to have to point, boom. Because when you file a false imprisonment claim, when the false imprisonment claim is filed, what the judge his responsibility is to determine whether what happened to you, based on what you've placed in the body of your complaint, is justified and meets the elements of false imprisonment, right? Because when you think about false imprisonment claim, that false imprisonment claim carries about 5 different elements that should be present, that are automatically present. You got 1, false imprisonment. I'm going to abbreviate more to save time. You got 2. If false imprisonment was established, and you know that by chapter 1 of the treatise on false imprisonment, you know what that says. It constitutes, what constitutes false imprisonment? There's 2 elements that have to be apparent, and they're literally in the name. So you ain't got to go thinking you got to have the exact definition of false imprisonment, because if I give you the exact definition of false imprisonment, this is what I'm going to give you. On page 5, if you've downloaded the treatise, you will be able to follow along with me. If you didn't, all you got to do is go to the YeSharon Moabite StarAcademy.com, hit the class assignments page, because I took the passcodes off, hit the class assignments page, hit false imprisonment, and click on the image that looks like this, and it'll automatically come up in PDF file, and we're on page 5. If you want to kind of follow along with what I'm saying, because you ain't gonna sit here and on the side of the road or while you're traveling, you're not gonna say, well, false imprisonment is forcefully to deprive a man of freedom to go wherever he may is a clear trespass. That's another claim, a trespass. If you've proven false imprisonment, meaning false, unlawful, imprisonment, restraint, detainment, then you've met the first element, because it has to be a detainment, and that detainment has to be, on page 6, has to be unlawful. Now, what would make it lawful? There's principles that we're going to go. But once we've proven that it was unlawful and it was a detainment, we got number 1 checked. Boom. Now, because it was a false imprisonment, it automatically was a trespass, right? Once it's a trespass, what's the next avenue? Well, depending on how this particular situation escalated, and if it did escalate, then you have assault and battery. That's your 3rd. And you could keep going down with claims. These are all claims. And these are all civil claims. Because I'm talking about a civil, everybody likes to call them tort, I don't like to use any words that's going to help confuse the people. I'm just going to say it's a claim. It's a civil claim. It's an injury. It's a breach of trust. It's a breach of duty, and it's a breach of due process of law. That's another violation. Number 4, due process of law. You got due process of law. What else do you got? You got color, which are not all in this treaty. Then you have what? Number 5. What's number 5? What are the violations once you can prove false imprisonment? Because a false imprisonment, again, is an unlawful detainment. It's an unlawful detainment, an unlawful restraint, and a violation of your due process, right? So you got false imprisonment, you got trespass, you got assault and battery, you got due process of law, a violation of due process of law. What you say? You going back? You be right back. Well, you're going to have to sneak out. Color of law. You got color of law violation. Don't fall down. You have color law violations. Does anybody else have any ideas of any other violations? Islam, transitive movement, holding, Islam. I'm just trying to see if we all on the right page. Give me some more violations, because a lot of you guys been in this class for a long time. I don't have my handy dandy phone or my handy dandy computer to go look up other actions. What are some of the other actions that you would add to this? What are some of the other actions would you add to it? Just seeing if anybody's going to participate in what are the claims. So these are just the 5. I guess we'll stick with 5, and I'll have all of them put down for you. So trespass is automatic with false imprisonment, depending on if it's an assault and battery, because you were violated, right? If I go back to the end of my documents, because I've listed out all of the definitions, and then, which would be separate to that, would be malicious prosecution. And you got to do one or the other. You're either going to have false imprisonment or malicious prosecution, or you're going to add on malicious prosecution to false imprisonment. But based on the treaty, what it talks about is that you got to do one or the other. It tries to make it seem you got to do false imprisonment, malicious prosecution, right? But I wanted to give you the definition of a trespass, why that violation, that action, that claim is there. Because a trespass is doing an unlawful act or an unlawful act in unlawful manner to injure another's person or property. An unlawful act committed with violence, actual or implied, causing injury to the person, property, or relative rights of another. An injury or misfeasance to the person, property, or right of another done with force and violence, either actual or implied, right? So the actual violence of a trespass would be you being put in handcuffs, or you being placed in the back of the cruiser, or you even being held within the jail cell for for even 5 minutes. If you're there an hour, if you're there 5 minutes, if you never even make it to the so-called jail, they let you go prior to that. That's all constitutes false imprisonment. And even if you were detained for 5 minutes, that's considered false imprisonment because they didn't have the right in the beginning. They didn't have the right in the beginning. And that is what Moors, we have to focus on, the fact that they didn't have the right in the beginning. And because they didn't have the right in the initial claim, all of these different charges can be brought up. There's more. I just can't think of them right now because all I got is this handy dandy notebook in my hand, which, not notebook, treaty in my hands. And I'm just trying to get started because we've been through all of this in our false imprisonment classes. Once you have the firm structure towards the end of this class in relationship to false imprisonment, the next one will be, well, how do you represent yourself as a pro se litigant? Now, the pro se litigant is the same thing as a impropria persona. in propria persona, in one's own right, right? It's my right to defend myself from the claim that you're accusing me of, right? So as a pro se litigant, you're going to learn what elements need to be met within your claim. Not only what elements need to be met, but then how to start drafting your documents as a pro se litigant, right? And then how to conduct yourself in court, how to make sure to get those documents filed, and make sure you're following the rules of court. That's also going to be another page. Once it'll probably be uploaded maybe middle of next week, possibly, in regards to what are the procedures, because I feel like Moors find this very, very difficult, and it is when you're reading documents and you have to refer to this document, you have to refer to that document, because most individuals lose their case by not following the rules of court. So it's going to be like a 3 or 4 tag class where you first find out, do you have a claim? Well, in order to find out do you got a claim, you got to find out what, based on what happened to you and how what happened to you fits in these claims and these elements. Because we didn't go too far, because what I want to go, what would be part of due process of law? Well, there are certain situations where they can, okay, am I paused? Hold on. Okay, I was paused. Hold on. Okay. I was paused for a minute, y'all. My apologies. Hopefully the next time we're on this class, it won't be so riggedy-diggity. It feels riggedy-diggity. But we're back on live. Let me see. Islam Empress. Okay. My reader of the comments isn't currently here right now, so give me a minute. When he gets back, he'll be reading the comments so I can kind of get your comments as opposed to moving in and out of camera phase. Okay? So what I'm saying is the 3 classes that are kind of coincide with each other, and I guess I'll put the classes here because at the end of this, my job, if I'm an effective instructor, is for you to first determine, do you have a claim? That's the first thing we are to identify. Do you have a claim based on false imprisonment? This is a civil claim. This is a civil action against a defendant, right? Against a defendant for unlawful restraint and a lack of due process. So I'm going to try to sit here and link this all up together, because the first thing you got to do is find out if you have a claim. So when you find out you have a claim, the next thing is to process said claim. Once you process said claims, now you gotta, and part of the process said claims meaning civil claim. Action, some people call them an action, right? So the first thing is, do I have a claim based on what happened to me? Second is, now I need to figure out how to process this claim by drafting it up. Because you're going to, if you're smart, go pro se. Be a pro se litigant. I didn't spell that quite right because, I'm bending down. I'm going to have to start erasing to get more information on the board. So the first, find out you got a claim, right? Based on the evidence, based on the action, based on the what happened to you, right? Then after you find out you got a claim, you got to draft it up. If you go to the representing yourself in court as a pro se litigant, that page that was just posted a week ago on the platform is what's going to help you process your claim. So the first, the second, and the third will be how to present yourself in court. How to conduct yourself in court. As well as how to file it. That's where the rules of civil procedure come in. That's where the rules of civil procedure come in. So that's going to be a part of all of these classes. The rules of court. Knowing what the rules of court says. Moors, if we're going to learn these things, then we have to use them. I don't teach this just to teach it, Moors. I don't teach this just to teach it, Moors. I teach it so you can use it and you can defend yourself. Islam? So that being said, the first section, you got to find out, do you got a claim? So you have to find out, does the things that happen to you constitute a claim? Then you got to process it. You got to learn how to conduct yourself in court, and you have to abide by the rules of court, because most claims get dismissed because people don't draft them correctly. They don't ask for a remedy. Well, you're not just saying this person violated me. You're saying this person violated me, and this is how much I want for that injury, right? Injury. That is your damages. Your damages have to be in your claim. What are you seeking? How much do you want? A prime example was, obviously I'm bringing this up, the P. Diddy case. The civil case that Cassidy filed in 2023, last year, against Sean D. What's it? Sean Diddy? What is it? Sean Diddy? What's his name, Trayvon?
I don't know.
My son don't know his name because that's before his time, because I just found out Sean Diddy Combs. Sean Diddy Combs is a Sean Diddy Combs. He's 54 years old. I didn't know he was that old, and he's a Scorpio. He liked to hide. Scorpios are secretive, if you know anything about astrology. So of course he was sitting here doing all these crazy things and hold people hostage with things that they were doing because he's secretive. That's what Scorpio. So right now, with all the people, like, anyway, I'm going beyond the point of why I brought up the case that Cassidy filed, the civil case that Cassidy filed in civil court to hold Puff Daddy. I don't even know what to call him. To hold Mr. Combs too. So she filed a claim. She filed a civil action against him. She filed a civil action against him for the injuries of knowing him and being involved with him for several years. I don't know how many years that she was with him, but she filed a civil claim. If anybody know, before she filed the civil claim, she went directly to him and said, look, if you don't pay me $30 million, I don't know what she was asking, but if you don't pay me $30 million for all of the pain and suffering I endured and the violations that I endured living with you, being with you, if you don't do that, I'm taking you to court. And we all do that, right? We all put in an original affidavit to say, look, on this day you did this to me, and it was against the law. And even if it wasn't against the law, you've injured me. Now, it's my job to prove that an injury did occur, so I have to have evidence. But at the same time, I have to have what I'm asking the court to give me as damages: punitive, compensatory, actual. These are all different types of exemplary. These are all different types of damages that I'm asking for, right? Some of these are actual that can be validated and estimated. And some of these are pain and suffering, the trauma. Now, every time I see somebody that look like Mr. Combs, I go into I go into some type of rage or some type of thing. So the point is, what's the point of sitting here saying all this stuff happened to me? And doing all of this, if you're not going to put what you're asking to happen, what you're asking for as a very relationship to the injuries that you suffered. Because sometimes some people don't suffer too much of an injury when they're violated, but at the same time, you have to tell them what you want in your initial claim. You have to determine based on these different violations, and if it's more, right? Some people might have lost, their lives, and they're not even here to file a claim from some unlawful detainment because it lacked due process, right? Because a lot of times I will have individuals tell me that they literally weren't doing anything. Now, obviously, people will embellish that their innocence in a lot of situations. My job is not to determine your guilt or innocence. My job is to determine whether your rights were violated. That's an attorney's job. That's a lawyer's job. That's a counselor's job. My job is to find out what happened and if there can be an injury for which damages can be sought. That's my job. My job is not to condemn you or to praise you, but it's only to say, yeah, you do have a case. You do have a case because that was an unlawful detention because they didn't follow due process. And we know that policy enforcers are required to follow due process of law. They're required to follow it. They give an oath to support the Constitution. They give their oath and allegiance to these positions that they hold because they are not regular employment positions. If you're going to violate somebody's rights or if you're going to execute a warrant, whether it be valid or invalid, you need to know what you can personally be held responsible for you not knowing what you're supposed to know before you interact with anyone. Right? So my job here is to show you these different fundamentals. Islam. So where do we go next? Because when we first started, we were in false imprisonment. That was the first chapter. The second chapter talked about, because we know false imprisonment is what? An unlawful restraint. Now you know that section was long. The first section gave you a lot of definitions, a lot of court actions to let you know, well, what the heck constitutes false imprisonment? What has the courts been saying about false imprisonment? What does it mean? Now you can go through that, Tracy. It's not a lot of work, Moors. We have to learn the study game. We have to learn the study game. We have to learn the study game, right? If you go to it, and this is an example that I used on one of my previous platforms, the answer was, or the situation was, you go to a store. You go to a store and one of the security guards, on your way out of the store, one of the security guards tries to detain you. Well, Moors, we have to know what is the difference. And I'm going to erase the board, so I hope, well, this is a video, you can watch all this stuff later. But this is a video, so I'm going to erase the board and talk about the elements, right, of detainment. Because there's something we have to learn to make sure is a part of our claim. And it has been spoken, it has been expressed. We can't just sit here and say, oh, he violated my rights, if we have not challenged that interaction lawfully on the scene when it happened, Morris. We can't sit here and always say, oh, well, I didn't think of this at that time. Well, I wasn't even paying attention. I didn't even know. We have to know what it is we ought to be aware of, right? And this gonna kill you because a lot of times people won't even realize did you give consent? And what kind of ways do they sit here? They try to sit here and when you get detained on the side of the road for whatever, and you didn't even think, well, did I give consent? Did I give consent to the search? Did I give consent to the search? Because sometimes, did I ask, if he or she had a warrant, right? This is, I think, chapter 3. Did I give consent, man? Did you give consent to the search? Did you give consent to the search? And did you tell them? What did you say? But guess what? That don't matter. They know they got to get consent. And even if you say, yeah, man, go ahead, man, because he's sitting there like, look, I'm going to tow your car, I'm going to put you under arrest, I'm going to put you ain't going to go home. And a lot of people, they don't necessarily give consent, but they don't necessarily give them permission, right? Because even if under threat, duress, or coercion, you gave consent, right? And a lot of times we want to sit here and we want to say, well, under threat, duress, or coercion, I'm giving you consent to search. Well, why would you say that? Well, why would you ever say I give consent in any situation? Did you ask him for a warrant? There's only 2 situations, Morris. You got to learn your laws. There is a such thing as a warrant or warrantless search, right? And they meet different elements. So if they have a warrant, it meets one element. If they don't have a warrant, it meets due process. So with a warrant, and we talk a valid warrant. It's got to be a valid warrant. And we got to know what a valid warrant means, and we have to ask to inspect it. We absolutely have to ask, do you have a warrant? And if they say yes, we'll produce it for inspection. So you have to say, well, produce it for inspection. And be comfortable saying that. They're going to threaten you. They're going to say all types of things because they're trying to legitimize or to make what they're doing unlawful lawful. And they do that through consent. Because they're always going to say, well, he gave me consent. Well, how can somebody give you consent? Why would somebody give you consent? And then you ultimately find something, right? So if I have I don't even know what to say. If I have fentanyl, like a lot of fentanyl in my car, why the hell would I consent to you to search it? Why would I do that? Nobody would do that. If you have some type of incriminating items, paraphernalia, what do they call it, contraband, if you have contraband in your conveyance, why would you consent? You wouldn't. No person would consent to a search if they have contraband. Nobody's doing that. So, for a warrant and for consent and to search. So the thing that most people need to understand, and the basic thing that we need to understand is the first question is what? You get somebody come up to you and be like, yo, I'm Officer Harry.
Shoebob.
Huh?
Shoebob.
I'm Officer Harry, right? So I don't know who Shoebob is. What? I'm Officer Harry. And somebody fitting your description just robbed a liquor store down the street. Well, that's hearsay, right? He don't know who you are. He said you were somebody who was described to look just like you was robbing the drugstore or the liquor store down the street. Well, what would be your next question? Well, I didn't, right? Well, no, I didn't. I'm just walking, minding my business on my way home from work or from whatever. And what if they say, well, where are you coming from? Well, it's none of your business. Am I under arrest? Am I being detained? That should be the very first thing you should ask a policy enforcer when they interface with you. Am I being detained? And if I'm being detained, then that means you probably either have an arrest warrant or or I breach the peace. There's only 2 elements, right? 2, for which they can interface with you without a warrant. Matter of fact, so let's understand the difference. A warrant and without a warrant. If they have a warrant, You got to determine. I need to inspect, because unless that warrant is valid and he has it on his persons, you do not have to. The law says you do not have to comply. So if he has a lawful warrant, right? If he has a lawful warrant, he has to have it in his persons. It doesn't necessarily have to be on his hip or in his pocket, but it better be in that cruiser that he arrived in, right? It better be in that cruiser, because if he doesn't have the warrant, he lawfully cannot detain you. It has to be either on his persons or really close by. Really close by, right? So, but you need to inspect it. Why do you need to inspect it? To find out if it is valid. Because people be having unlawful warrants. And you need to validate whether that warrant is lawful. And under chapter 6, which is page 46, if we go to page 46, we start with a warrant, right? The use of the warrants. And to find out if a warrant is valid or not. And there's a lot of elements that have to be, why can't I get this page open? That have to be prevalent or aware in order to validate a warrant. Okay. So, for a warrant to be valid and to be lawful, for which you have to comply, because it's an order from the court. Understand what a warrant is. The warrant is issued because of what? Probable cause. And what constitution, what amendment in the or article in the constitutions is where the law of warrants governed? Where in the Constitution is the law of warrants governed? Does anybody have that answer? Where the law stands as it relates to a valid warrant? Does anybody know where it says that in the Constitution? That's a good question. Because if I'm not mistaken, I don't got the Constitution in front of me because it's not my body politic, but the Constitution, if I'm not mistaken, under Amendment 5 or 4, I think it's 4. Can anybody confirm that? Fourth Amendment, Islam. The Fourth Amendment talks about no warrant will issue without probable cause. Does anybody know what probable cause mean? What does probable cause mean? Probable cause, because I can't see the screen, y'all. Probable cause means reasonable cause, having more evidence for than against. And I think that's the part you really need to understand. It can't be just a suspicion. It has to be probable that you not only are the person that they're looking for, you did the crime that you are ultimately going to be, that you were ultimately charged for, which is what issued the warrant, a charge. There has to be a charge. And that charge is where the probable cause comes from. So they may have had an individual who's a witness that saw the crime or saw you enact. That's probable cause. So a witness would go into the precinct, right? Go into the prison. I'm not the precinct. The police department, and they file a complaint. So say they file a complaint and they say, this individual raped me 3 nights ago when we were on a date. I mean, it could have been, I'm not going to use the date one. I'm not going to use the date rape. Say you were walking and you were assaulted in the alley and you saw the individual's face. Not only did you saw the individual's face who assaulted you, say he had a tattoo. And then the next day you go to the precinct and you know who it is because you just know who it was. You go to the precinct and you file a complaint. You file a complaint saying John Doe raped me the night before, and you identify him as being a specific person. You saw his tattoo. You know it was him. You've seen him around in the neighborhood. You can identify him. So now the police would have, based on that complaint, right? Based on the complaint by the witness, based on the complaint by the witness, they have a charge of rape. Now they have a charge of rape. They have the initial complaint filed. So the DA goes to the judge for a warrant because they have probable cause, reasonable cause, and they have evidence. The evidence they have is a witness's lawful affidavit taken under oath that these charges can be filed against this defendant. So then they get that warrant is executed by the facts that was presented to the judge, and then they go execute that warrant. Let's fast forward. The John Doe that assaulted that woman was found coming out of his house, right? He came out of his house on his way to work, and then they say, we have a warrant for your arrest. Well, the first thing that defendant is going to say is, can I see and inspect the warrant before I comply? Right? That's if it's like harmonious like that. It might not even be harmonious like that. It might be all of a sudden you try to get in your car and all of a sudden people just attacking you, right? All of a sudden people coming in, guns drawn, like 70 of them, 20 of them, 15 of them, 5, and then they pull you on the ground. Well, no matter what part, you're supposed to say, look, if you got a warrant, show me a copy of that warrant. I need to see the warrant. It has to be in your hand. If they didn't have that warrant, y'all, if that warrant was across town, was in a different jurisdiction, then that was an unlawful arrest. Because that warrant has to be present. You can't just go, just because you know it's in the system, that sheriff is responsible to come and present that warrant. Well, actually, the person that's arresting is supposed to have a copy of the warrant. Why is it not even a copy? That original arrest warrant supposed to have it, not a copy, because you need to validate whether it's an actual warrant. Why is it supposed to not be a copy? Because it has to be signed by the judge, and you got to validate that. It can't be stamped by the judge. It has to literally be signed. The elements of a warrant, right? A warrant is to be issued by a judicial officer and signed by him. It can't be signed by the clerk. The clerk can't stamp it because the clerk ain't got no authority. That clerk is an administrator of the judge. So what the clerk should be doing is getting that warrant signed by the judge before that DA comes to pick up the warrant. He ain't supposed to be stamping it because the judge told him to stamp it. He don't have that authority. His authority does not extend. The authority that the judge has to sign and issue warrants under that judicial branch of government does not extend to his associates. They're associates. They're employees. They don't have the authority to sign a warrant. So that's the number one. Has to be signed by an actual judicial officer. Next, it must state the facts that show the matter to be within the jurisdiction of the judicial officer issuing it. What does that mean? That means, now when the so-called DA goes to the judge to get a warrant, he has to go to the judge within the jurisdiction for which the incident occurred. Now, what happens in these situations currently? They go fishing for judges. A lot of claims can be dismissed just for the simple fact that they went and got a warrant outside of the jurisdiction for where the incident occurred. So you can't be in Montgomery County and then you go run all the way to Bucks County for a warrant. Well, that judge don't have the authority to sign a warrant in this county because that judge's jurisdiction is over here. A case can be dismissed just for the simple fact that you got to see what judge signed the warrant. Did he belong to the right jurisdiction? Because a lot of the policy enforcers fish for judges. And they can't do that either. But guess what? Our people don't even be knowing that they fished for that judge and that judge didn't have the authority to issue that warrant. That's how the warrant ends up being invalid and unlawful, which gives you what? false arrest civil case. You arrest him. Not only does it give you that, it gives you dismiss for lack of what? If y'all go to the website where it says representing yourself in court, they had the different types of motions to dismiss, right? Motion to dismiss, lack of jurisdiction. We love to use that, but do you really know what it means? Because if a judge outside the jurisdiction for which the offense occurred, he didn't have jurisdiction to issue that warrant. And if he didn't have jurisdiction to issue that warrant, well, was the case filed in the right jurisdiction too? Gotta ask yourself that question as well. Islam? The third element it cannot be based upon belief or suspicion, right? But on probable cause, the warrant. So in this situation, they did have probable cause because the individual identified the man to a T as it relates to what happened. Not only did she identify the man, because 9 times out of 10, if you're sexually assaulted as a man or as a woman, you know the first place you probably should be going is to the hospital. After you go to the precinct, they're actually going to make you or suggest you go to the hospital because they need to compile evidence by doing swabs, right? Taking pictures of your injuries. You know, making sure they have the evidence to put him or her on the scene. Not just your testimony will be the only determining factor. That won't be the only determining factor. Right? Because they want to prove it and they want to win their cases. Even though they should be taking every case, even unwinnable cases, because if I file a claim against somebody, how dare you not prosecute? Especially if I'm telling you it happened, like let a court of law determine whether or not we have enough evidence to support the claim. Right? Islam, lack of due process. So that was the third one. The fourth one is the warrant is to list a complaint, which is to state the offense committed and the facts that constitute the crime. That's kind of like the affidavit. That's kind of like the initial complaint. Like, what does the initial complaint say? Now, what's the charge that's based on the initial complaint? They should match. I'm trying to tell y'all, a lot of these cases can be won just from the initial complaint being false in every aspect and not in the charge, not supporting the claim. Right? So that was number 4. Number 5 was what? And I'm on page 55, by the way, if you're not aware of what page I'm on. A warrant is to be supported by a signed affidavit made under oath by the person stating the charge. So that's where they're talking about, they call it an initial complaint. Under oath, it's filed under oath, right? So you got to say, this is not perjury. I stated the facts to the best of my abilities on this initial complaint. So the initial complaint is going to support, based on what the person who's filing the complaint, based on what they're saying, is going to tell. They're going to find out what charge to file it under, based on the initial complaint by the so-called witness or the so-called accuser. And must truly name the person to be arrested or describe him sufficiently enough to identify him. So it has to describe him sufficiently enough to identify him. And that's where, for the so-called rape example, the fact that she saw his tattoo, that could be a way of identifying him if she couldn't really say who he was. And sometimes, I think this only happens really in the movies, but it might happen in real life, and it's not really supposed to, but I'm not sure, where they'll drive you around to see if you see the individual, the witness, if they're interested enough. Because we talking movies. In real life, it don't really go that way, in my opinion. Don't really go that way. And then the last one is, the warrant must also command that the defendant be arrested and brought before the nearest available magistrate. Now think about that, Morris. The nearest available magistrate. They're talking about within a specific jurisdiction. Because if you're in your right jurisdiction and you're not going outside of your jurisdiction to fish fish for judges or people who do you favors, then you're not going to have an issue because you're going to take them right down the street because you're in the same jurisdiction for which the incident occurred because it has to be there. But a lot of times people don't know that because they don't know what the elements that need to be present. They don't know the elements that need to be present for that warrant to be valid. So what was the 4 or the 5 different situations that I gave you? And like I said, it's on page 55 through 56 of the treaty that I just talked about. I had no room on this board. I always run out of room because I write too big. So the first one, the warrant must be signed by the judicial officer. It must be by a judicial officer within the jurisdiction for which the incident occurred. Has to be based on probable cause. It must list the offense that is being. The warrant must list the complaint, which is to state the offense committed by what constituted the crime. It must have a sworn affidavit. It must truly identify the person in the so-called warrant. So think about the Jane Doe warrants. Do they even have how are you gonna have a Jane Doe warrant? Everybody, anyway. And then lastly, the warrant must be commanded to bring the defendant to the magistrate. And why are they bringing them to the magistrate? To answer to the charge. What do you say against this claim that's been brought up against you? This crime that you're being accused of committing. You have to answer yes or no, or guilt. I plead guilty. I plead not. I plead innocent. I plead no contest. I challenge jurisdiction. Whatever, you got to answer for that claim because now they got to figure out whether or not the crime is not necessarily just a arrestable defense. Like, are they going to give you bail? Are they going to release you? All of that stuff got to be determined by the judge. So what I'm ultimately saying is a policy enforcer's only authority is to bring you in front of the judge. They're not to do anything before that. When they arrest you, that arrest warrant gives them the approval to violate your liberties to answer to a crime that you have been accused of. That's their only authority with a valid warrant. Because they're agents to the court, who's the one that has jurisdiction. The court officer is the one that has the authority. The judge is the one that has the authority. His job under that jurisdiction is to hold people accountable to the laws of that state or county or municipality, whatever one you want to call it. They're all kind of the same in a sense. That judge has the right to call anybody in this court as long as these elements are represented. He can't just call you in here and say, yo, I want to talk to you. Go pick her up. There's got to be a violation. He only has the authority to adjudicate claims against another individual, injuries, or civil cases and civil matters. So realize that policy enforcers don't have a right to detain you unless a judicial officer of the court gives them a valid warrant to do so. You understand? And thank you, that was Amendment 4 of the Constitution that says a warrant will not be issued but upon probable cause. Because we don't have the authority to take your liberties away. I erased it off the board. If we're going to violate your liberties, the only way we can do that is if we have a lawful warrant that's saying that you violated someone else. And I mean when I say someone else. Because an injured party has to be a corpus delicti, an actual injured party. Someone filing a complaint against you. And we know most of the time these complaints that are filed against you by the very people who don't have the authority, who are asking for a warrant. A lot of the initial complaints are filed by a policy enforcer or a detective, saying that you violated a code, but there's no injured party. Right? So now, what situation has to be present for a warrant to be, for you to be arrested without a warrant? Because this one, just like you said, was Amendment 4 this one is by amendment, if I'm not freaking mistaken, 5. So what situations constitutes that you can be arrested without a warrant by a policy enforcer? Because I'm trying to get you to think. He can't arrest you unless a judicial officer gives him the authority to deprive you of your rights. Because his immunity for civil cases is based on the lawfulness of making sure things are being done right. So it's in his best interest if he's executing a warrant to make sure that joint is valid. Because if that warrant isn't valid, he can be held accountable in a false imprisonment suit along with the DA who prosecuted it, who initiated the case. Because it's the district attorney office that's bringing these charges against you. Because the policy enforcer is only supporting it with an affidavit. Like they're not even supposed to be. They're supposed to be the affidavit. The initial affidavits or the initial complaints are not supposed to be signed. I mean, the so-called policy enforcer is the one who drew it up, but there was supposed to be an actual injured party who signed off on the complaint that was filed. And we're not making sure this is happening. The Constitution gives you the right to face your accuser. If you're and how you gonna draft up your defense against the claim if you don't know who's violating you, who's claiming that you violated the law? He can't be anonymous. He has to be identified. Because you are defending yourself and you have the right not to face your accuser. When we say right to face your accuser, I have a right to say what you think you saw against me that initiated this whole process. Islam, my son abandoned me. I can't answer any of the questions because my son abandoned me. He came and he left. So where are we at? Arrest without a warrant. It's only 2 situations where that can be done. Only 2. And you're going to see the game that be played to try to get this to stick. That's 1. That's 2. He has to actually see both. Can't be on anybody else's testimony. Or it won't even be a testimony, somebody saying it. So somebody saying, "Oh man, I saw this guy down the street, he was beating up on this girl." Well, you gotta come in and file a formal complaint. Do you know who the girl was? Do you know who the guy was? And you saw that? You didn't witness the felony in progress. I'm sorry. You didn't witness the felony in progress. You have to see it. Breach of the peace too. Breach of the peace. What's a breach of the peace, Morris? What is a breach of the peace? I hope y'all doing y'all assignments, because let me tell you, this is how you're going to argue your argument. A lot of times in court cases, a lot of the proceedings is written. Answers, defense. You're gonna be filing things to the court all the time, so you're gonna have to be able to defend yourself, and you're gonna have to be able to say to know these different things, because this defense or this not this argument on the criminal side, if you got some fake charges based on that arrest, it's also your defense. It's your defense in a criminal and your argument in a civil. Think about it that way. So a breach of the peace. A breach of the peace may be generally defined as a violation of the public order which amounts to a disturbance of the public tranquility. You're making a lot of noise, right? Or by citing others to do so. So, some violence or harm existing or threatened to occur to person, property, health, or morals. Affrays, assaults, riotous conduct, or destruction of property make up the largest part of what can be called a breach of the peace. Thus, in the majority of cases, a breach of the peace, some actual violence is present. That's the breach of the peace, y'all. What's a felony? You know what a felony is? Because everything that's so-called identified as a felony ain't a felony. In today's climate, I'm trying to get you to realize that we sit here and get all scared about people saying, about prosecutors saying, oh, we're gonna give you 40 years. And as soon as you hear 40 years, your whole world, you just turn into like the Wicked Witch of the West got the water thrown on you. You just start melting away. And you didn't even realize all he did was try to threaten you and scare you into doing what? Make a deal. Let's make a deal, right? They got a movie, they got a TV show. Let's make a deal. That's all the prosecution trying to do is let's make a deal. And their job is to see how much fear they can put in you to make a deal. And guess what? Guess who the people who don't even do anything, who are not, they're just standing accused of something. And they're feeling like they did something based on, oh, you're going to get 40 years for these charges because they, just like you're going to do on your civil case, rack up these different claims based on what actually happened or what arguments you can prove. Right? They gonna put as many charges against you to see what sticks, what you come to, what you agree to. So when I go to felony, a felony is a crime of a graver or more atrocious nature than those designated as misdemeanors. Generally, an offense punishable by death or imprisonment in the penitentiary. I can't even say the word. In jail. I'm just gonna say in jail. So if I go to the chapter that talks about a felony, if I could find it quick, I think that starts on page 30. So if we go to page 30, Morris, and I don't know where we at in our time. All right, we're doing good. If we go to page 30, right? It goes a little deeper in terms of what a felony is, as well as what a misdemeanor is, and different things like that, and what a breach of the peace is. So I'm kind of trying to peruse it real quick to see if I can find out what it says, because it says something, conditions of felony arrest, threatens a breach of the peace. Give me a minute. I'm trying to find it. Where's my definition? Because the definition of a felony and the different types of a felony were a little better than what that definition that I just gave you admitted to. A type of felony is rape, larceny, kidnapping, murder, physical assault, like these things of a physical nature. Because what? Harm has to actually occur. You have actually had to have physical harm or property, right? Property damage was kind of under a breach of the peace in a way, and a misdemeanor, right? Kind of. Because a felony, it wouldn't find, a felony is injury to another person. It really is a grave injury to another person. So murder, manslaughter, like when you, if you were traveling your mode of conveyance and you were under the influence of alcohol and doing that, you there was an accident and the person in another vehicle or somebody walking was injured severely or even died in that situation, that's a felony. But they have a lot of other things that is not listed, that's not a grave violation or is listed as felonies in these states because they want to keep you in jail as long as they can, right? So they classify things that are not even an injury towards another as a felony in certain state statutes, and that's a breach of what? State laws cannot supersede the federal laws. Laws that states establish against the Constitution for the United States of America is notwithstanding. It says that in the Constitution, right? So we got to realize The more you know, the better defense you have, and the better argument you have, the better claim you have. And it's going to end in a positive result for you. It has to end in a positive result for you. Right? If you haven't done so, I would love for someone to share this live on Facebook, because I don't have time to be doing that while I'm doing my lives. So these are different things. So if you're, the only way they can arrest you violate your liberty without a warrant is for these two situations. And only these two situations. A misdemeanor is not automatically a breach of the peace. What are different types of misdemeanors? And even moving violations. They are not allowed to arrest you for those. I'm just trying to say they're doing a lot. They're doing a lot. And they're doing a lot because we don't know the law. And then when we get in there, the first thing we're trying to do, because we want to get back on the streets and we want to get back home because we have jobs and we don't want to lose our jobs and different things. And they know all of that, which is why they do the things that they do. They cannot take your property. They cannot take your property, take you, search your things without these two conditions being met. And even if you do a breach of the peace, they can't search your stuff. If you partake in a felony, that only gives them the right to arrest. Then they got to go get a probable cause warrant based on that. So this only gives them the right to detain you without a warrant. Just you. They got to get a warrant for anything else. And then they got to bring you in front of the magistrate to see how you answer to these charges against you. Whether you plead innocent, whether you plead guilty, whether you plead no contest, where you challenge jurisdiction. Well, now you're in the realm of, now I got to fight this libel. This is another name for a complaint. Because the accusation is being lodged against you, whether it's lawful or not. And a libel is something that's considered unlawful. Back in the day, that's what everything was called, a libel. And that's L-I-B-E-L, a libel. That's old school. So we went to so far what? What did we go through so far? What a false imprisonment is. And if I do a good job at this part, because where are we at now? We're at 8:30. So we got about a good 30 minutes. Because I'm going to end at 9 o'clock. At 9 o'clock and overstand on Tuesdays. Last Tuesdays, I wasn't able to do our third class on law, on international law. I might try to make it up this weekend, or I might just wait and then have that class next Tuesday on the same platform. Because like I said, I'm wearing many hats right now, Morris. I'm wearing many hats, and sometimes one of those hats got to take precedent over the other hat. So when I'm not able to, which is why I moved over to the live classes. So if I'm in class, I'll be on YouTube Live. But if I'm not in class, then that means class is not in session. Because I'm not always going to be able to send you emails and notifications. I'm trying to do make it a little bit easier for myself when doing these classes. So let's do a little recap. This is something you should definitely be writing down. Recap. First is what? False imprisonment. Right. And for false imprisonment, that is whether it was unlawful and a detainment. Those are the elements. Boom. This is how you figure out. Now, once you find out you meet that, now you have to do your claim, right? You meet this. Now you got to do a claim, which is also an action, right? And the top 5 is number 1 is false imprisonment. Action number 1, false imprisonment. Action number 2, assault and battery. And you can just put A and B. Number 3, because all of these happen, is automatically a trespass. Number 4, a violation of due process. Number 5. What was number 5? What was number 5? Y'all remember what number 5 was? Oh, color law. Guess what happens when people file civil claims? Guess what happens when people file civil claims? And these is just the top 5. I'm going to get the rest of them because it's way more than that. These are just the ones that I can remember or recall off the top of my head. Over abuse of power. Abuse of authority. Right? Shucks, if you got shot, let's say you got shot in that altercation. What could we call that? It's more than assault. Attempted murder? Shucks, it's a civil case, y'all. Put as much as you can. Attempted murder. But I'll get all of them because they all have to meet certain conditions. They all have to meet certain conditions. Shucks, attempted murder? Well, what happens if your child was killed? And you found out through all of the things that you're researching, my child died because of that unlawful arrest. What are the additional charges that we gonna put on this? Right? Violation of oath. I don't know what else I want to put up here. Right? I'll think about it and I'll get back to you. So once you get false imprisonment, now you got your claims. You know what your false claims means. Now you're drafting up your different arguments. What constitutes false imprisonment outside of that? What arguments? What do you have to prove in your claims? Well, the first thing you have to prove, it was a false imprisonment. You're proving that by your arguments. Based on the facts. Supported by evidence. Supported by the evidence, right? Sometimes when you have this false imprisonment, you may have charges that were established because of that false imprisonment. You'll realize you have arguments in terms of motions to dismiss that case in addition to that. Because if a case of false imprisonment, you're going to have to decide between the two. Either false imprisonment or malicious prosecution, which I didn't even get into. Because in order for you to add the action of malicious prosecution, the criminal case that was lodged against you was dismissed favorably to you. So if they charged you with some random charge to validate that false imprisonment, and you fought that case and won that case, meaning it was dismissed against you, now you can put malicious prosecution on that. But the criminal case has to be favorable to you before you can add malicious prosecution. Because why are we saying malicious prosecution? Because they just made up some damn charges to hold you. They made up charges that don't even fit the what? Initial complaint. You got everything stems on that initial complaint filed. So that is your meat and your potatoes in the criminal case against you. Or the civil case against you. Because you're supposed to, just like Taj Tariq Bey says all the time, you gotta hit point for point. So if they got 7 points in that initial complaint, and you'll know the point numbers, because you'll go to the page on the website that talks about representing yourself as a pro se litigant. Representing yourself as a pro se litigant, but I think the page name on the website is representing yourself in court, right? So if they got 8 actions or 8 so-called charges against you, you have to have a defense for all 8 charges. And that defense, you have to add all of them, right? Yep, point for point. That's one thing that we've learned from our classes, our early days with Taj Street Bay on House of Reawakening Minds. Big ups to both of those platforms. I learned a lot. If it wasn't for those platforms, none of us would know what we know today. And that's real rap, because nobody was teaching this stuff prior to House of Reawakening Minds, prior to Taj Street Bay, as well as RV Bay Publications. Those was the stomping grounds. Those was the precursors for all of us, because they're the ones that kind of got us even on the right page. Because for the whole time, we was on the wrong page. So I'm always going to promote and give big ups to them, because they are the reasons we are even at this stage in the game. So Islam to them. So you have to answer the action point for point, because just like you gotta have facts and arguments to support these claims, they have to have a defense, and the defense would be they have to prove what they did to you doesn't constitute false imprisonment. So they have to prove what they did to you was lawful, and they did follow due process. You ain't filing a false imprisonment case if they follow due process, if they have a valid warrant, if they have an affidavit of facts and different things. Now you can't necessarily prove false imprisonment. Now you're going to have to go to due process and see where in that can you kind of kill their defense against you, or a complaint against you. So don't always just, as soon as we go through something, think it's the end of the freaking world, and think that we have to get these attorneys, because what is an attorney? They turn you over to the jurisdiction of the court and they leave you there. They don't defend you. They don't even present the proper argument, because a lot of these cases that go against that they pull into those jurisdictions could have been killed on their face with just looking at the original complaint and seeing if they had any real evidence against you. Islam? Right. What else? So here's the blueprint so far. We got false imprisonment, unlawful detainment. We got to meet those elements. And then then here's the part where you're going to kill them with either a warrant or a breach of the peace or a felony. They have to have one of these things, and they got to be lawful. They have to have one of these things, and they got to be lawful. So if they don't have a warrant, and it wasn't a breach of the peace, and they didn't see you witness you committing a felony, well, it was all unlawful. So then you got to figure out, okay, once you file your claims, and like I said, this can be used for both civil and criminal, right? So it can be your defense, a criminal, or your argument to support your claim, in civil. And then we go down to, once we got all that, where we moving to next? So once you have all that, now you say, okay, I think I got all the elements together. Now the third part, just like I was telling you, you find out which one these breaches, because this is what they're gonna have. If they have a warrant, they're gonna have to make sure it's a valid warrant. If it was a breach of the peace, they're gonna have to be able to support that with evidence. Obviously, they can't support that because you wasn't doing anything. And if you was doing something and they got you, now you got to make sure they follow due process the whole way. My job is not to determine innocence or guilt. I'm just here to give you the law. You're supposed to know how to defend yourself, Morse. Islam? So the third part, once we get to this whole part, now you got to draft your civil case. Now you got to draft your civil case. Now, one of the things Moors are very uncomfortable with, well, once I get the action in, once I know that I have a case, well, how do I draft up the documents? How do I present myself or present my claim? Because we're so used to everybody doing things for us, we don't realize we have a lot of power. And that power is in what we can learn and what we can start to do to defend ourselves against a criminal case, as well as to present a civil case because of a violation. Because a lot of these attorneys ain't going to take these cases. They're not going to take these cases. They're not going to do it. They're going to sit here and hide behind some statute, try to get you to hide behind some statute. But if we do not enforce the law, how can we sit here and say we have rights? We got to challenge these individuals when they violate us. So you have to start drafting your case, and now you have to start getting yourself ready for court. Moors, this is not complicated. They try to make it seem like it's complicated, try to talk real fast, try to say real legalese that make no sense. I'm going to create another page on the website, and that other page on the website is going to be called Rules of Court. Because all rules of court, I'm going to tell you, is uniform. Because the rules of court is based on the federal jurisdiction. So it's based on federal, even though they all have their own version of rules of court, depending on what court action you should be putting your claim in, depends on the monetary amount of your claim. So in order to put it in district, has to be over, your claim has to be over $75,000. And that's what the jurisdiction you want to be in anyway. Because you have constitutional questions. Those constitutional questions can't go in the lower court. They don't got jurisdiction. The lower courts only got jurisdictions over the subject matter that the Constitution for those states has given them. It's the only jurisdiction they have. So when you bring in constitutional challenges in a lower court, that's why you're not having a favor. They don't have jurisdiction over that subject matter. They're municipal and ministerial administrators. Their job only is to interface with their procedures, their laws that's based on the statutes of their jurisdiction. They don't have jurisdiction over constitutional violations, which is what we're talking about when we talk about warrant or warrantless detainments. So we got to know what court to be taking certain things in. Because one thing you know, they fish for jurisdictions. They fish for judges, and they're not allowed to do that. Judges have jurisdiction over certain subject matters based on the jurisdiction that they are in. Wherever the crime happened, that so-called judiciary has jurisdiction over that. They cannot go outside another jurisdiction. They can't do it. But they're doing it. Why? Because we don't know the law and we don't hold them accountable. And we need to start doing that, Morris. We need to start doing that. So where are we at? I went fast today. That's because I got my handy dandy board. I love my board because it makes me go fast. It makes me put it in chronological order, and it helps me to help you, help us. Because I'm working on that tonight, which is why I was late today and having technical difficulties. I was working on a rules of court page. I was working on a treatise on the rules of court, so you can just keep going down to those particular situations. Because I had months ago somebody asked me, well, they're asking me to file an answer. Well, what do you mean they're asking you to file an answer? People call me with no pretense and just say, well, I'm like, I need background, and that's going to take time. My time, I deserve my compensation for what it is that I do charge for. Because I do charge for private consultations just so you can understand what you need to be focused on. And realize you can file claims within, but you got to follow the rules of court. A lot of cases are freaking dismissed with or without prejudice based on the fact of it was an improper service. And because you're going to be dealing with people who have attorneys, they know the rules of court. They know that, okay, you got a certain amount of time to do this, and we're going to go through that later. You got a certain amount of time to do that, and if you don't follow the proper protocols, they're going to get a dismissal in their favor or a default judgment in their favor because you didn't follow the rules of court. Meanwhile, neither do they. Not always, because they know you ain't even going to think about filing anything, because we were stuck for a long time. When we were under that Moorish American ideology, we were stuck a long time just stay at a standstill fighting for just jurisdiction, not even knowing that pursuant to the ICJ case, France versus United States, because the Moors at that particular time didn't establish states for which they could have nationality. We had a lot of things missing, Moors. Had a lot of things missing. Those are not missing in a lot of situations now. So, like, the things that I kind of want to talk about is just, don't get focused on the wrong thing. Stay focused on the right thing. We like to have debates for 20, 40, 50 years when the law can't be debated, Moors. It's stated how it is stated. You just got to comply. We're the only ones around the world thinking that we don't have to comply to the law and then wonder why we don't ever have any positive remedy. And then we coming in there with all this negative energy, and that's not serving us at all. What did Prophet Noble Ali say? If you go in there with an intelligent tone, you'll get a favorable reply. That means you can't come in there acting like a Negro or a Negress. We got to learn how to be adults. Because let me tell you, I be on social platforms and I see people operating outside of a divinity, outside of nobility and honor, and I just don't understand, because we talking 40, 50-year-old people. I'm here to just teach you the facts, Moors. I'm here to teach you the facts. I'm not trying to get my point across, get you to follow me, or get you to idolize and worship me. I want to give you the evidence so you can make the right decisions for yourself, so we can do the things that we're supposed to do as a nation, or as a state, or as an organization, or as an LLC. Whatever it is you decide to do, just do based on what the law talks about it, and have the proper argument, and don't be in your feelings. When you don't get a favorable reply, just find out why you didn't get a favorable reply, or put your administrative processes in place or in action, right? So we're coming up on what time? What time is it, Moors? What time is it? What time is it? Islam. I miss you guys too. Like, I could have sent a notification, because I have a big email notification list, but I'll be wanting to send it out because I want you guys to kind of help me, to help you, and help us, whereas though I don't have to do all the work, because it's a lot of work. I'm doing so many things at one time, and sometimes I find it difficult to manage my time. I do find it difficult at times to manage my time. I do find it difficult. What do I have? What are the last questions? Because I don't want to go too far. I don't want to go too fast. Even though this treatise is not long. It's only 9 sections. It's only 9 sections, and we went through pretty much all of them. We went through pretty much all of them, because the reality is, even when they have a warrant, or they don't have a warrant, they got to bring you in front of the magistrate. That's their authority. Because they don't got no without that authority. The only authority they got to is these situations to breach your liberties. These are 3 situations for which they can breach your liberties. These 3 right here. They got a warrant, and if they don't have a warrant, if you're breaching a peace or a felony in progress. If these situations are apparent, the only authority that they have after that to detain you and strip you of your liberties is to bring you in front of the magistrate. And they have to bring you in front of the magistrate in a reasonable amount of time. That is what article or chapter 8 talks about. No, chapter 7 talks about bringing the arrested person before the magistrate. And movies will lie to you and say, oh, they got 72 hours before they have to spring you, or they can detain you for 72 hours. No, sweetie. As soon as you get detained, under these three situations, as soon as you get detained, under these three situations, one of these three situations, their only authority is to take you in front of the judge, because that is the judicial officer. The judge has to get you to answer to whatever it is they're claiming they have. A warrant, and a warrant usually is issued because of a felony, 9 times out of 10, or because you were breaching the peace. And then the judge's responsibility is to look at the initial affidavit, is to look at the charges against you and to determine whether or not, and for you to answer to those charges, whether innocent, guilty, not guilty, or no contest. So based on how you answer and how you conduct yourself in court will be what they use to determine whether or not you get bail bond or you get released on your own recognizance to fight these charges that are against you. And based on the severity of the charges that are against you, will determine whether they give you bail or hold you to trial. Right? So the first thing they have to do is take you in front of the magistrate to answer the charges, and they don't have 48 hours to bring you in front of the magistrate. As soon as they arrest you, you're supposed to be put in a holding cell within a reasonable amount of time. It just says reasonable amount of time, but based on court cases, reasonable amount of time is about 4 hours, tops. They gotta bring you right in front of the magistrate. Guess what they're not allowed to do? They ain't allowed to question you. They're not allowed to fingerprint you. They're not allowed to do any of these things until you go in front of the magistrate. Because the magistrate might see if he's a good judge or whatever, he might see the claim and be like, I don't know, I've never heard of a magistrate dismiss a case. It usually has to at least be, you have to at least answer to the charges through the magistrate. You get bail or bonds, or you get released on your own recognizances, and then you sit there and file your appropriate documents to fight that case. But I'm telling you, Morris, you gotta learn this stuff, because these attorneys ain't trying to help you. They get paid from the state. They're licensed from the state. They work for the state, and before they even had their private practices, they were working for the state to get the darn experience, or working for a private firm as a paralegal, as whoever, assistant counsel. Right? I'm trying to tell you, this stuff's not difficult. We have to just get used to the terminology, get used to participating this way, and then understand when you go into these tribunals, not necessarily tribunals, when you go into the clerks of court offices and you start acting and putting things on the record, and they try to sit here and stop you from doing all the things that you're doing, and you getting all these attitudes, understand why you're getting that attitude, Morris. You're getting the attitude because they know they're violating your rights. They know it. That's why when they see you coming in there, they get uncomfortable. The darn demons start popping out because they like, yo, the jig is up. Well, of course. They never should have been able to put 95% of our populace in jail under frivolous charges. But if we knew the law, a lot of our people, a lot of our family members wouldn't today be in those facilities. So once they bring you in front of the court to answer to the charges, right? The next is you defending. Now you gotta start defending. Now you gotta start getting all the documents and information to fight against that case. A lot of cases are won by people who are even guilty because of due process violations. They didn't follow protocol. And if they didn't follow protocol, there is no, understand why law is so important. If you understand why law is so important, you would understand why due process of law is your best friend. They gotta follow the law. They can't violate your liberties. They can't sit here and hold you to these things that are not lawful. Only reason why they're doing it is because all the attorneys are agents to the same. They're not going to give you the proper argument. They're not even going to challenge the warrant because they know darn well when the warrant. They know what they're doing against you, and they're getting paid well to do it. And a lot of times, it's not from the pro bono cases that they do, it's from the law firms that they're trying to get in. They're not gonna get in a law firm if they keep getting people off of jail. If cases keep getting dismissed because the attorney, like, just think about it. Really think about it. If I'm a judge and all these cases are coming across my desk and they're all being dismissed, that's a direct reflection of the DA as well as the defense attorney. And think about your defense attorney. I'm not talking about the ADA. Just think about the attorney that's under you. He's got a private practice, right? Or he's under a private practice. The private practice is trying to make money. They make money because, one, you pay them. And then they make money too because think about every politician. It used to be an attorney. So like, they're not good. Their job or their goal isn't to defend you. Their goal is to further their career. And their scorecard looks good with convictions. What they got you to agree to, even though lawfully they could have got you off of those cases. Because a lot of those cases, if your liberties were violated, do you deserve to go to jail? Because your claim supersedes their claim. Because now, instead of them being a lawful or law-abiding citizen, they just became an outlaw just like you, just like they're trying to claim you are by not following law. I mean, these are things that people need to think about. We need to realize that the judicial officer's duty first is to the law. Their job is to be impartial. Their job is to know the law. Their job is to know those administrative procedures so everybody is being held accountable. And if you realize the rules of court in terms of even summonings and even in terms of dismissals, it's all in the rules of court. Now, my job as an instructor is to make sure you understand what your obligation is and how to make sure you are heard. But Morris, we got to get past the belligerency. We got to get past it. Even if they're being violent, we got to come from the noble place, right? We got to come from the nobility place. And we got to support each other. These classes is how I support each other, how I support us. Because as these states are being established, and as these Moors is learning what it is that they're supposed to know in law, we're going to have to know how to adjudicate in our court of laws. How can we learn how to adjudicate? We don't even know how to defend ourselves within the current jurisdiction that Moors find themselves under, right? And I'm going to take questions, but I want to let you know it takes finances to build a nation. Anybody to tell you shouldn't be giving donations to support people who are providing service, well, they're lying to you. Nobody else has this problem in terms of asking for donations for support of things that they're providing, services that they're providing. So I don't have a problem sitting here putting up donations, as well as, letting you know that it takes finance to build not only a nation, but it also takes finances to build your competencies, right? So support is always necessary, and I'm always going to ask for it at the close of my classes. And that is through either Cash App. I have the same Cash App I've always had. Islam. And if people just donated, if 100 people donated $5, the platform would pay for itself, right? Because it takes finances. You can send it through Cash App, donations, or you can send donations through Selly, through my email address. Everybody knows what my email address is. I mean, you should know it by now. It's a long email address. It's my appellation. Because I need your support to help build us up and build the platform that I utilize to provide you with the services and to provide you with the knowledge that not only am I learning, but I want to transfer, because my job is to transfer that energy back to you, and your job is to transfer energy back to me. Islam? So this is how you could donate to my platform. My platform is located on www.YeSharon Moabite Star Academy.com. That is the platform where all my course materials are. I currently have 3 courses that I'm doing. The 3rd course hasn't started yet. The one is on Tuesdays. Between 6:30 and 7 is when I normally start. It's always going to be on YouTube Live. All you got to do is subscribe to my channel. My channel is the YeSharon Moabite Star Academy. The same name as my website and the same name as, well, that's my name, but the same name as my website is my YouTube channel. So please subscribe to the YouTube channel and hit the notification button, because as soon as I go live, you'll get a ping, you'll get a notification on your cell phones or your electronic devices to let you know. On Tuesdays, we have international law classes, and we have international law classes because our people feel as though we can make up our own laws on how we come back into self-governance and sovereignty. We can't do that. We have to follow international law. And international law is supported by 193 United Nations members. 193 other nations have agreed to participate with the UN. That's what the international law classes on Tuesdays is all about. Getting you competent in understanding what the United Nations is. And if you've been in my class, you'll know their job is peace. Well, a lot of Moors will say, well, we're not supposed to be in the UN. And I challenge them, tell me why. A lot of Moors don't have a common sense in terms of what we're supposed to do because they don't read. And if what the UN is and what I understand is what we're all doing. Then you got Thursday class. Let me get to the point. Between 6:30 and 7. If I'm on time, I'm starting it at 6:30. And that class is the class you're currently in, arrest and false imprisonment. That is the next class. So you got Tuesday's class, international law. You got arrest. Thursday class is going to shift. The Thursday class is going to shift from arrest and false imprisonment once we're done. I've done so much on the treatise on false imprisonment. I'm going to roll over to same class, representing yourself in court. Representing yourself in court is going to show you how to fill out the documents and to draft your claims. It's going to show you that. That class is probably going to be the very next class after the very next class. So next Thursday, we're going to end false imprisonment. And because false imprisonment is just to show you. It's just to show you. False imprisonment is just to show you that you have a civil case and you have rights. And the only way you can actually have them is if you defend them. And if somebody breaches your liberties, you have every right to claim a remedy in civil court. So international law is probably going to go on for a long time because there's so much you need to know about international law. So that Tuesday class standing on international law is going to morph to treaties, going to morph all over the place in terms of international law. So that's going to be a standing class, but this Tuesday class is going to change from arrest and false imprisonment to representing yourself in court, as well as rules of court. In these classes, you're going to learn how to draft the documents, and you're going to learn how to get yourself prepared and ready for court. And then after rules of court, then we're going to go into criminal prosecutions. Boom, there it is. But this Tuesday class is completely and exclusively dedicated to international law. And that's going to be a very intense, probably a whole year class But I'm going to try to sum it up because I do not like to waste your time. I do not like to waste your time. I'm getting mad hot, y'all. And this class is about to end because I'm dying of heat exhaustion. Next time I'm going to have a fan because I'm overheating. So again, the Tuesday class is on international law. The Thursday class is going to go from arrest and false imprisonment. It's going to move over to representing yourself in court. After that, it's going to move over to the rules of court. And during this, we're going to kind of go in between all of them. And then we're going to, it's not necessarily we're going to end. Then the very next class is going to start criminal prosecutions, which is going to be a good, long, lengthy class. And it's going to probably stay there for a while. But while I'm drafting up these classes and while I'm creating these classes, Morris, you're going to have the documents, the templates that you need, and you're going to have the rules of court, so you'll have what you need to defend yourself so your case is not kicked out. And the more Moors that start doing these things, Moors, that start defending themselves, you'll see the change that you need to see out there in those streets. And if you notice, I'm like sweating my little booty butt off. But again, please give donations. Donations are necessary for me to provide these classes and to support the platform. So you can donate by Cash App, through Mac Northeast, same Cash App, Zelly. All you need is my email address, and that'll send the funds directly to Zelly in terms of that. Subscribe to my YouTube channel in order to get the notifications live. Make sure you hit the notifications button on the channel. The channel for the YouTube as well as the website is YeSharon Moabite StarAcademy.com. And if you look me up on YouTube, it's YeSharon Moabite Star Academy. Click the subscription button and click the notification button, and you will be notified of these courses that are going on. And I'm only got time to do 2 classes a week. I can't do more than that. That's just too much, and I think it's too much for you as well. So this class, this Thursday class, is going to rotate. So right now we're on arrest and false imprisonment. Next week we will be ending arrest and false imprisonment class, and then we'll be starting representing yourself in court. This page is already up, and I'm still drafting this page on the website. I'm working on this one. This one will come later. Don't have time. It's so much that I have to do in conjunction with these things. And I still do private consultations. I just don't promote it on my website, but I still do private consultations. If you need private consultations for anything in regards to the topics that we're talking about here, as well as trusts and different things like that I've always been providing, you can send an email to this email address and I will hit you back up. Islam, my contact information is also listed at the bottom of the website. Without further ado, are there any other questions? Because we are at 9:09. We are at 9:09. So I did go 9 minutes over, and I'm going to end with the Moroccan prayer or the Moorish prayer. And it is 5 on the left, 2 on the right. Allah, the Father of the universe, the Father of love, truth, peace, freedom, and justice. Allah is my protector, my guide, and my salvation by night and by day, through his holy prophet, Noble Jew Ali, Islam, amen. Have a great evening, and I will see you on Tuesday, where we will resume on Facebook, on YouTube Live, International Law. Peace and love, Morris.